right, we're going to get started. Thank you guys for coming to our last major Gideon event of the year. It's been a really exciting series that we've had with a lot of good speakers, and I think this is going to be one of our best. So I will introduce Professor Hoffmann, who is going to be moderating our panel. And Professor Hoffmann is our Harry Prater Professor of Law. He earned his BA from Harvard College and his JD from University of Washington. And he's previously clerked with Judge Kravitz on the 11th Circuit, and, sorry, I don't speak very loudly, and for Justice Rehnquist on the Supreme Court. And among other positions, Professor Hoffmann has served as the co-chair for the Massachusetts Governor's Council on Capital Punishment and has taught in universities at Japan and Germany, as well as being on the faculty of the National Judicial College. We are very honored to have our panel speak on a really important topic, and I'll let Professor Hoffmann take it away.
So I brought with me today a prop. It's my office copy of the volume of the U.S. reports in which the decision in Gideon v. Wainwright is contained. It's almost like the Bible. All right. So I'm delighted today to be able to introduce two wonderful speakers and experts on the subject of defense representation in criminal cases. And I'm going to do these introductions separately. In other words, I'm going to introduce our first speaker, and then I'll get back up and introduce the second one. Our first speaker today is David Carroll. David is the executive director of the Sixth Amendment Center, which is a national nonprofit organization that is devoted to assisting states and counties and other localities to meet their constitutional obligations to provide competent defense attorneys to defend people accused of crimes who cannot afford to hire their own attorneys. The Sixth Amendment Center's website declares that its purpose, its mission, is to ensure that no person faces potential time in jail without first having the aid of a lawyer with the time, ability, and resources to present an effective defense as required by the United States Constitution. So it's a pretty noble mission that this center is designed to fulfill. David himself is a nationally recognized expert on such issues as standards and methods for the delivery of right to counsel services. He consults with states and localities nationwide on a regular basis. Indeed, he just flew here directly last night, or I should say early this morning, from Idaho, where I'm pretty confident that was not a vacation trip, but a working trip to Idaho to help with defense representation services issues. David has spent over 15 years doing this kind of work, helping policymakers at the federal, state, and local levels. He also has led numerous research projects and written papers and reports, testified in front of state legislatures and the U.S. Congress. And without further ado, I will turn over the microphone to David Carroll. Thank you.
Good morning. Thank you very much for having me here. I've been asked to start things off with an overview of where we are as a nation in regards to the right to counsel on Gideon's 50th anniversary. And I couldn't help myself, but being out of school, I thought I'd start off with a pop quiz. You all thought this would be easy, right? This is a quote. It is not to be thought of in a civilized community for a moment that any citizen put in jeopardy of life or liberty should be debarred of counsel because he was too poor to employ such aid. No court could be respected or respect itself to sit and hear such a trial. Who knows what case that's from? Any guesses? It's a case called Webb v. Baird that was from Indiana in 1854. I bring it up because in many ways, Gideon is the culmination of a large history that's going on before 1963. Notice, for example, how closely the arguments in Gideon match one of our very first right to counsel statutes in the country. In Gideon, quoting Powell, they say, even the intelligent and educated layman has small and sometimes no skill in the science of law. Without counsel, though he be not guilty, faces the danger of conviction because he does not know how to establish his innocence. This idea of big government coming in to take personal liberty, it is an issue of tyranny versus liberty that predates even the revolution. This Rhode Island statute's from 1660, and I think it basically lays it out there that anyone can be charged with anything through malice or envy. And the important thing is to make sure we're getting it right and to make sure that the innocent are not being convicted. Indeed, the early embrace of the right to counsel by our forefathers is perhaps best demonstrated by John Adams' defense of the British soldiers involved in the Boston Massacre. They were found innocent, by the way, if you didn't realize that. Years later, Adams stated, "Counsel ought to be the very last thing an accused person should be without in a free country." My point is that the failings we are about to discuss today go to the core to who we are supposed to be as a people. Government should only be able to take the individual liberty of a person if the process is fair. So let's jump into what's going on across the country. And I'm going to start with another pop quiz. Which state was the very first in the nation to codify the right to counsel in all cases, including misdemeanors, and the requirement that attorneys be paid for such services? This happened in 1877. Any guesses? I'll give you a hint. It was a Union state during the Civil War. Are they always this responsive? Okay. Free pizza, I should have known. Okay. Most people wouldn't have guessed this. Nevada. Even though the right to counsel was established some 90 years before Gideon, Nevada has been sliding backwards since the implementation of Gideon. Most of rural Nevada relies on what we call flat fee contracts. In essence, an attorney agrees to take on an unlimited number of cases for a single flat fee. Now, this county that I've highlighted is a county called Lyon County. There, this one flat fee contract defender actually got appointed to the bench. But what that meant was his pending cases needed to be transferred to another attorney. The attorney they chose was a 27-year-old attorney who had only passed the bar exam a few weeks before he inherited this flat fee contract. So on the first day as tenure of public defender, he had 600 cases, 200 of which were felonies, many of which were murders, and there was at least one death penalty case. First day on the job, first day out of law school. So a brand new part-time attorney with no experience or training was expected to jump into a caseload that under national standards should have been handled by more than 4 experienced full-time attorneys. And all trial-related expenses had to come out of that same flat fee, meaning he had a financial incentive to do as little as possible on the case for his clients. And remember, attorney overhead expenses must come out of that same flat fee, including office rent, bar dues, all that sort of things. And Nevada counties are geographically large. Now down here is a county called Nye County. Now, for those of you from the East Coast like I am, you may not get a sense of what that means. Nye County is the same geographic expanse as New Jersey, Delaware, and Maryland put together, okay? A single county. They have 2 county seats, Pahrump and Tonopah, 2 sets of courthouses, 2 prosecutors' offices, and a single public defender. Not a single public defender office, a single public defender. So that means there's a great driving distance. It's about the equivalent of driving from Baltimore to Newark, which is about a 4-hour drive just to get to court. Now, one day court would be held in Tonopah, the next in Pahrump. So he had at least a 4-hour drive twice a week just to have court appearances. And remember, the cost of gas comes out of that same flat fee contract. Now, this attorney could not make ends meet. I remember talking to him and he was breaking down. He didn't understand how to do it. He wasn't making enough money. And so instead of getting out of the contract, this guy took a conflict office conflict contract in neighboring Esmeralda. So he added about 3/4 of the size of Connecticut to his geographic expanse as well. Now, there's an important case that you should all know about called United States v. Chronic that talks about these type of systemic deficiencies that result in unconstitutional representation. Now, as in Nevada, I would say that system there has lost the character of a confrontation between two adversaries. The constitutional guarantee is clearly violated under this form of delivery system. Now, Chronic says there's two ways the adversarial system breaks down. The first is a complete denial of counsel altogether. So the defendant never even gets an attorney. And this is America's dirty little secret. Thousands of people go to jail every day without ever having spoken to an attorney. How does this happen? Well, I'll tell you what cemented it in my mind. I was doing some work in Montana, and for whatever the reason is, I find myself doing work in Montana in the winter and being in the deserts of Nevada in the summer. So it was snowing, and it took a little time to get there. So I landed, I said, I'm just going to walk down to the courthouse, see what I see. Found a misdemeanor courtroom. I went in there. They're doing a bunch of arraignments for out-of-custody defendants. And as they were going through a video arraignment with no defense attorney there and clients saying things they shouldn't be saying out in public, I noticed this one gentleman who was about my age, mid to late 40s, clearly didn't look like anyone else. You can tell by body language he was very upset to be there. When his case was called, it turns out he is charged with stealing firewood. And no defense attorney in the courtroom, the judge asked him if he had done it, and he had said yes. Now, clients say a lot of things for a lot of reasons. He may have thought by admitting it was showing good faith and he'd get a more lenient sentence. But the judge asked him why he had done it, and he said that he had 2 small kids at home, that his wife was sick, and the oil company had shut off his heat, and that he needed to keep them warm in the middle of a Missoula winter. Judge kind of nodded her head, turned to the prosecutor and said, before I pass judgment and sentence him, is there anything you want to ask, Mr. Prosecutor? And the prosecutor said yes, stood up and said, have you ever done this before? The defendant looked around and said, well, yes, on 2 different occasions. The prosecutor said, I'm changing my charging instrument to reflect 3 charges, which made it a jailable offense, and the person went off. Now, there wasn't even any proof that a crime had been committed, let alone anything else. So as I was sitting in the courtroom, the cases were going, I started standing out like a sore thumb. I didn't have cowboy boots or a hat on, so people knew I was an outsider. Judge finally said, who are you and what are you doing here? And I introduced myself. She was very happy to have someone from the East Coast and suggested that I come back to Chambers to continue the conversation, which I did. And I told her, I said, Judge, I have to tell you, this one case is really standing out in my mind because it's not even a Shelton violation, it's an Argesinger violation. Argesinger is the case after Gideon that extends the right to counsel to misdemeanors. She goes, Argesinger, that's interesting. Do you have a citation for that? And I said, well, Judge, I do, but it is the prevailing law in your courtroom. See, she wasn't a lawyer. And in this country, in many, many misdemeanor courts especially, where felonies start and misdemeanors are heard, you don't have to be a lawyer to be a judge. And so she was just accepting whatever the prosecutor wanted to do that. Chronic then goes on to say there's other instances in which the structure is so deficient that even if there's a lawyer present, no one could ever provide effective representation. And they point to a specific case, Powell v. Alabama, which is the Scottsboro Boys case. And they took issues with all sorts of things in this case, including judges handpicking the attorneys, insufficient time to prepare the case, lawyers weren't qualified to handle the complexity of the case for which they were given. If there's a case that you really want to read start to beginning, I think it's Powell. Now, in 2002, the ABA promulgated a document called the 10 Principles of a Public Defender System. These are 10 simple tenets that are used to educate policymakers about what they need to do to have an efficient system. And many of these reflect some of the same things that were pointed out in Chronic. Now, in Nevada, and the most important one in my mind is the independence of the defense function. Principle 1, because you're not going to get the rest of the principles if you don't have that. In Nevada, at the time I visit, the judiciary oversaw every aspect of indigent defense, which attorneys got the assignments, how much they were paid, whether they had access to experts. This violates this principle because when you do that, the attorneys are going to take into account what they need to do to please the judge to get their next contract or case, rather than what's in the best interest of their clients. Now, let's look a little further at independence. When I was in Louisiana, prior to their most recent statutory changes, Louisiana law required that each local government, their subdivisions are called parishes, but they're like counties everywhere else, have an indigent defender board. These boards were tasked with all aspects, hiring and firing of chief defenders, qualifying attorneys, approving budgets. Well, in this one parish, the indigent defense board was comprised of the lone criminal court judge's secretary, the secretary of the sheriff, and the secretary of the district attorney. In another one that I visited, the judge had appointed the local high school vice principal, a nightclub owner, and a part-time embalmer. They did exactly what the judge and the district attorney told them to do. So what does the U.S. Supreme Court say about independence of the defense function? Well, in 1981, the court determined that states have a constitutional obligation to respect the professional independence of the public defenders whom it engages, observing that a defense lawyer best serves the public not by acting on the state's behalf or in concert with it, but rather by advancing the undivided interests of the client. The court concluded in this case that a public defender is not amenable to the administrative direction in the same sense as other state employees. Independence of the defense function goes as far back to Powell versus Alabama, where they say specifically about judicial oversight, how can a judge whose functions are purely judicial effectively discharge the obligations of counsel for the accused? He can and should see to it that in the proceedings before the court, the accused shall be dealt with justly and fairly, but he cannot investigate the facts, advise or direct the defense, or participate in those necessary conferences between counsel and accused, which sometimes partake of the character of a confessional. So, judicial interference. Let's divert quickly to Texas. There, it's statutory that the judges are in control of the indigent defense system. Now, a report in 2000 commissioned by the state bar shows that roughly 1/3 of judges sometimes consider whether the attorney is a political supporter or has contributed to their campaign before they'll make any appointment. When public defense attorneys are forced to take such things into consideration to what it's going to take to please the judge, they are by definition not solely advocating in the best interests of their client. Under this circumstance, it doesn't take a judge to overtly say, hey, don't file any motions in my courtroom, I want to get out on the golf course by 3. They simply internalize that and know what they have to do to get that next one. So why are there not a lot of chronic claims out there, especially around the issue of judicial independence? Well, as detailed in our report from earlier this year, Reclaiming Justice on Nevada, the same financially conflicted attorney who is handling the trial representation is more often than not the one that's appointed to handle the direct appeal, meaning he will not raise ineffective assistance issues against himself. The first real chance of raising IAC occurs at the post-conviction stage, where a defendant may raise new issues about the constitutionality of his conviction beyond what is in the trial record. But of course, there is no federal right to counsel in post-conviction appeals, and Nevada only appoints counsel in post-conviction death penalty cases. So if there is no counsel, there is no investigation, there's no ability to develop the factual basis for a chronic claim. It's a real catch-22 in our country. Now, I've focused on judicial interference, but there's political interference as well. For example, New Mexico has a state-funded public defender system, but the chief defender is a direct gubernatorial appointee. The governor also is allowed to appoint or terminate any person under him, any supervising attorney or line attorney. What this means is that there's a revolving door in the public defender's office with each new administration, and line attorneys know they can simply wait out the next government appointee if they don't like what the chief is asking them doing. Now, in 2011, Governor Susana Martinez fired the chief public defender in the middle of budgetary hearings for having the gall to say that the governor's budget would not be acceptable for them to be able to handle the caseload they have. Now, lest anyone thinks I'm picking on Republicans, this exact same problem happened when Bill Richardson was governor of New Mexico as well. In fact, one of the articles in the newspaper said that the person he appointed to the public defender office that had no management experience whatsoever was the single largest attorney contributor to his reelection campaign. In fact, Bill Richardson vetoed a bill that would have overwhelmingly passed the legislature that would have created an independent commission to buffer between the undue political interference. Again, this is a problem in several states, and it crosses both political boundaries. So Chris Christie did it when he took over governor. He fired the sitting public defender, put in someone there. Howard Dean did the same thing in Vermont. A little different. Dean did it towards the end of his tenure because he didn't like what the public defender was doing. But I'm happy to report the tide is slowly turning on some of these issues. On November 6th of 2012, this is incredible to me, the New Mexico electorate voted overwhelmingly for a constitutional amendment requiring a statewide indigent defense commission. The bill creating the commission passed the legislature in March of this year, and the commission is now up and running. In 2007, the Louisiana legislature abolished the locally judicially controlled boards in favor of a central independent board. There's even some tiny movement in Texas where Travis County Judiciary, Travis County is Austin, recognized that having judges oversee the payment and indigent defense counsel was, in their words, leading to conflict, disagreement, and dispute which negatively impacts the relationship between judges and lawyers and undermines the respect and dignity with which it's required for the criminal process. They are currently implementing in Austin a managed assigned counsel program that has an independent director not tied to the judiciary. And even in Nevada, the Nevada Supreme Court handed down a sweeping court order in January 2008, removing the judiciary from contracting directly with defenders. The same order set performance standards for attorneys, defined a uniform definition of indigency, and other jurisdictional specific studies to help them create caseload standards and others. It's a really great document. They just took it upon themselves. They did it, by the way, because when you're thinking about how states work and how different cultures work between our states, in Nevada, the legislature sits for 24 days every other year. Getting anything passed that doesn't have to do with gaming is very difficult, and so the court took it upon themselves to do it. In closing, let me just do a little plug here. I write a national blog called Pleading the Sixth that details all these stories. Put up here some nice things people have said about the blog. Please visit our website. We send out email notifications. You can sign up on there if you want to be able to get these alerts and stay current about what's going on across the country and how these problems are attempted to be solved. Thank you very much.
Thank you so much, David. It's my special pleasure to be able to welcome to our law school today Norman Lefstein. Norman is a professor of law, although at this point, I guess we'd say semi-retired, something like that. Also, formerly the dean. He is the dean emeritus of the McKinney School of Law in Indianapolis, just up the road, our sister law school. Norman, prior to being at IU McKinney, was a faculty member at the University of North Carolina in Chapel Hill and has also held appointments at Duke, Georgetown, and Northwestern. But it's a real treat for us because not only is Norman essentially a neighbor up the road, but he is also one of the nation's leading experts on the subject of public defense. Prior to entering the academic life, Norm served as the director of the Public Defender Service for the District of Columbia, one of the most highly respected offices of its kind. He was also an assistant U.S. attorney in D.C. and a staff member in the office of the Deputy Attorney General of the United States Department of Justice. Norm has written a number, or helped to write a number of publications, many of them published through the American Bar Association. His most recent book, I have another prop here, is on securing reasonable caseloads, ethics and law in public defense. He received the National Association of Criminal Defense Lawyers Champion of Indigent Defense Award in 2005. He spent 17 years as the chairman of the Indiana Public Defender Commission, and in 2002, he received the Sagamore of the Wabash from then-Governor Frank O'Bannon. So, without further ado, I will introduce our second speaker, Norm Lefstein.
Thank you very much, Joe, for those kind remarks. I'm real pleased to be here in Bloomington and at the law school once again. And it's a tribute to all of you that you're still here because I see the pizza's all been eaten. So I have to assume you have some interest in what I might say. And of course, I'm delighted to talk about public defense in Gideon and hopefully save a few minutes if you have questions. I want to reminisce a little bit with you about the right to counsel from my vantage point. And I have a long history of the right to counsel, and I don't want you to gasp when I say this, but I graduated law school in 1961. That's 2 years before Gideon was decided. And I began taking criminal cases in the District of Columbia as part of a graduate program in law that Georgetown University Law Center started. I started that in 1963, 6 months after Gideon was decided. At the time in Washington, D.C., one of the more progressive places in the country, lawyers from major law firms were volunteering to take cases in felony cases. And at the misdemeanor level, there really weren't hardly any lawyers available by assignment. There were some, but they were the same lawyers who were literally gouging clients for money. Verbatim story. I had a lawyer tell me from the cell block that he had just interviewed his client. The client didn't have any money, so he would plead him right away. Lawyers would stand up in court, this is recounted in some texts, and say, "Your Honor, I need a continuance. I'm still looking for Mr. Green." And the first time I heard it, I thought, well, who in the world is Mr. Green? And then I heard that same witness was being sought over and over and over again. And of course, the lawyer needed his money from the client, and he hadn't gotten it yet, so the judge would continue the case. Lawyers who reeked of alcohol in the bathrooms. And all of it tolerated by a complacent judiciary. And I think Washington may have been one of the more progressive places in the United States at the time. And when it comes to the right to counsel, it still is well ahead of the rest of the nation. Recall the state of the law when Gideon was decided. The only decision that really guaranteed a lawyer was Powell versus Alabama, decided in the early 30s. And that was only a right to an attorney in a capital case in the United States. As far as felonies were concerned, the prevailing law of the land was a decision in 1942, Betts versus Brady, that said, if a judge were to find special circumstances available, the judge should appoint a lawyer, meaning that maybe fairness would require that a lawyer be assigned. And judges rarely did find that special circumstances were available. Indeed, the ACLU, in its brief in the Gideon case, wrote, the special circumstances test has plagued state courts. It has not operated to protect the accused, nor to facilitate the sound administration of justice. And they went on to say that rarely is counsel appointed pursuant to Betts versus Brady. As far as misdemeanors were concerned, there was no right to a lawyer at all unless a jurisdiction were to see fit to appoint counsel, which was rarely done. Gideon actually illustrated the law's failure. If you read the Gideon decision as part of a course in criminal law or procedure, you may recall a colloquy in which Gideon stood before the court and said, the Constitution guarantees me the right to a lawyer. But he was wrong. It didn't guarantee him a right to a lawyer. It guaranteed him a right to a lawyer only if the judge found, quote, special circumstances. And in that Florida case, the judge didn't even pause to consider whether special circumstances were present. After all, it was a petit larceny of a pool hall involving a small sum of money that was stolen. And he simply said, your request is denied, no lawyer will be appointed. But after conviction, Gideon was actually acquitted when he had counsel. And the case was remanded after the Supreme Court decision. The Gideon decision gave a very significant impetus that I had an occasion to observe as a young lawyer in the United States after it was rendered. There were, to be sure, a small number of public defenders in the United States prior to Gideon, but there were not many. The first program of public defense was actually begun in Los Angeles County in 1914, but it was nothing like the 700 or 800 lawyers that populate the LA Public Defender's Office today. In DC, where I was practicing, there was the forerunner to the public defender program that I later headed and that Professor Hoffmann referred to that had about 6 lawyers in it. Some very good lawyers, but they handled a very small number of the cases, quite obviously. After Gideon was decided, the state of Florida moved quickly to establish public defenders in the 16 circuit courts throughout that state. The Ford Foundation made available $6 million as part of the National Defender Project to spread the growth of public defenders throughout the United States under the auspices of the National Legal Aid and Defender Association. And soon after Gideon, there were other important decisions. One of those was N. Ray Galt, decided in 1967, establishing the right to counsel in juvenile delinquency cases. And I'm the only one in this room who heard Galt argued in the U.S. Supreme Court. I was there because at that time, I was providing lawyers in juvenile courts in several major cities in the United States as part of a Ford Foundation grant. And we were seeking to study how that impacted the juvenile and what effect it had on outcomes. And that was followed in 1972 by the Argersinger case to which David Carroll referred, in which the Supreme Court made it clear that if you are going to be imprisoned and you were going to lose your liberty, you had a right to a lawyer, and that has effectively been translated into a right to a lawyer in misdemeanor cases in the United States. Today, there are probably somewhere between 15,000 and 20,000 public defenders in the United States. There are many private lawyers who provide representation either by serving as assigned counsel, receiving very inadequate fees for doing so. And there are a lot of lawyers who take cases pursuant to contracts. More than half the states in the country have some kind of a statewide system. Some have hybrid systems like we have here in Indiana, some money from the state, some money from the counties, most of it from the counties here in this state. Most defender programs have at least some access to investigations and social workers, occasionally paralegals. Overall, there are thousands of persons involved in defending people in the United States, and there's usually some funds available for experts needed by the defense as a result of the Supreme Court's decision in 1985 in Ake versus Oklahoma. There are various kinds of training programs, national, state, local programs. Here in Indiana, the Indiana Public Defender Council has a series of training programs for public defenders and private lawyers. You have various standards for how to provide representation in criminal cases. The defense function standards to which Professor Hoffmann referred are ones for which I served as a reporter for the American Bar Association. We set forth there, and others have set forth how it ought to be done, consistent with U.S. Supreme Court decisions, but very few, if any of them, are really enforceable. There's a wide variety of clinical programs in law schools, in this law school, externship programs in the prosecution and defense area. There's all sorts of innocence projects, national as well as local, and some in law schools. And overall, the funding has increased quite dramatically for public defense, something in excess of $5 billion now being spent in the United States today, even though that data is hard to come by in precise detail. In short, the landscape of public defense in America over the last 50 years has changed in very significant ways. At the same time, the problems in public defense in America are absolutely enormous. The difficulties should embarrass anyone who cares about justice in America's criminal and juvenile courts. When the Supreme Court rendered those decisions back in the 60s and the 70s, it was an enormous unfunded mandate imposed upon states in this country. There was no legislation. There was legislation when the Federal Defender Program was created in 1964, which received its impetus from Gideon, though a movement was underway to establish the Criminal Justice Act even before Gideon. The Criminal Justice Act in the federal courts came with an appropriation, and until 2013, it has been a model in the United States. Something for everyone to emulate, because you have federal defenders who are very well paid with reasonable caseloads, very significant support services, and on the other hand, you have the private bar involved. And they are reasonably well paid, or at least they have been, at $125 an hour. They have access to support services, and they are screened for their qualifications. And then sequestration set in 2013, and it is decimating the federal program. The one brightest spot in public defense in America was hurt badly by sequestration up until October 1st, when the second phase of sequestration set in, and now it's even worse. And it faces many of the same problems that permeate public defense in the state courts in America. Several years ago, I was a member and reporter for a national study of public defense. And we issued the most in-depth study of public defense in America, published in 2009, titled Justice Denied, America's Continuing Neglect of Our Constitutional Right to Counsel. It was under the auspices of the Constitution Project and the National Legal Aid and Defender Association. It was a bipartisan commission, and it's available on the internet if you search for Justice Denied. In the report's executive summary, here's what I wrote that was embraced by the commission. Today, in criminal and juvenile proceedings in state courts, sometimes counsel is not provided at all, something to which David Carroll alluded. and it often is supplied in ways that make a mockery of the great promise of the Gideon decision and its soaring rhetoric. Throughout the United States, indigent defense systems are struggling due to funding shortfalls, excessive caseloads, and a host of other problems. Many are truly failing. Not only does this failure deny justice to the poor, it adds costs to the entire system of criminal justice in America. Well, it goes on for page after mind-numbing page of some of the problems, as well as proposing certain solutions. In Chapter 2 of Justice Denied, we outline some of the major problems. I'm not going to spend much time on them, but first and foremost, we certainly talked about the funding problem. When I speak about funding problems, I cannot but recall the words of Justice Lewis Powell, who was a very practical Supreme Court justice who once headed the American Bar Association. And he referred to the funding of indigent defense as an acute problem. And he wrote in a footnote in the Arger-Singer versus Hamlin decision in 1972, the successful implementation of the majority's rule extending the right to counsel in misdemeanor cases would require state and local governments to appropriate considerable funds, something they have not been willing to do. Well, Justice Powell's words have been prophetic, because they weren't willing to do it in 1972, and they haven't yet been willing to do it in 2013, and all the years intervening. Other ways in which deficiencies are present. Obviously, excessive caseloads is a huge problem, one to which David Carroll alluded, one which my book deals with, although it deals in addition to the whole structure of public defense in America. I was involved, just to do one better than David Carroll's example, I was involved in a case in Florida as an expert witness several years ago. And the public defenders there, post-arraignment, were taking on 750 felony cases a year, many of which were extremely serious felony cases. Totally impossible. And they were engaged in a kind of triage in representing clients that they knew to be an enormous problem. Although they've been doing it for so long. They've been doing it for so long that it really became part of the culture of some of the lawyers there who said, well, you know, we managed to get through it all somehow. All kinds of other deficiencies, which I will skip over, except to mention what is in this country the over-criminalization of minor matters occasioning the right to counsel. And one of the ways at the lower level to address the issue is to take away criminal penalties in circumstances where they really are not necessary. But let me mention, before concluding these remarks, a couple of points. The need for effective lawyering has never been greater than it is today, even though the difficulty of providing effective counsel remains daunting. And I say it simply because we imprison more people in this country than any other nation on the face of the earth. And we impose the longest prison sentences of any nation on earth. In fact, as a country, we imprison so many people that even though we have only 5% of the world's population, we're number one in putting people behind bars. China, with a population 4 times our size, for criminal offenses has only 1.6 million people behind bars, roughly. How many is it, by the way? 2.2 to 2.3 million people behind bars in America today. And of course, there's another reason that counsel is vitally important, and it's one the Supreme Court didn't know anything about in 1963. Some of us suspected it, however. We know that the criminal justice system in this country and the juvenile justice systems make terrible mistakes. They get it wrong time after time after time. We know it since the first DNA case in 1989, and we see it almost every day in this country now. That kind of certainty was not present when Gideon was awarded a new trial. Good lawyers can never prevent the mistakes that occur in our justice system, but let me tell you that if you don't have a good lawyer, and law enforcement and the police are hell-bent on conviction, and if that lawyer has an enormous caseload and doesn't have access to investigative assistance, doesn't have access to experts, you just don't have a chance. And when you look behind the cases of wrongful conviction in this country, which is a project I'm working on with the Innocence Project, what you find is very inadequate defense representation. Let me close with something that permeates public defense in America. And that's the reality that what so often happens is a form of triage, dealing only with the most immediate case, much like a surgeon in an emergency room deals with the patient who is bleeding and needs to be attended to first. I don't mean to suggest there aren't thousands of dedicated public defenders and many private lawyers who are dedicated to what they do. Because there are many, many lawyers who are dedicated, and there are some good defense programs in this country. But there are darn few of them when you look at the landscape as I have and as David Carroll has. You can go to almost any place in the U.S. and find the kinds of problems that we can talk about. But I said I wanted to say a word about triage. I'm serving as an expert witness in a major class action case in the United States challenging the defense services provided throughout the state. I'm privy to thousands of pages of discovery, trying to read them and digest it all. And then I came across the most impressive smoking gun I've ever seen about a public defender's office in a large county, 1.5 to 2 million people. And it's a memorandum to the lawyers in the agency. And I knew the agency had way too many cases. I knew it from the data I had looked at and from other materials I had seen. But here's this memorandum, and what does it say? It says to the lawyers, quote, "The initial encounter with the client, though an inadequate opportunity to allow for a thorough discussion of the case, should provide a sufficient opportunity to triage the client's case to determine if further comprehensive dialogue is necessary with the client." There's that word. They even put it in writing. And then there's the deposition of one of the leaders of the agency who says, and this is a quote, "If a defendant does not deny committing the crime and is willing to accept a standard plea, there is no reason for the defender to investigate the case, file motions, or consider going to trial." You know that quote that David Carroll had up there from Chronic versus United States in 1984? It talked about adversarial testing of the state's case. The defense lawyer has an obligation on behalf of his or her client to counsel about whether or not a guilty plea should be entered, but never to plead a client guilty until you have investigated the facts of the case. Because even if the client admits guilt, and the standard makes it real clear, your duty to investigate is a duty that has nothing to do with whether the client admits guilt. It's a duty to subject the state's case to a form of adversarial testing. And even if in the end you decide to plead the client guilty, your investigation may form the basis for a lesser sentence being imposed, or even for the charges themselves being dismissed, or lesser charges being filed. That's not what that public defender agency was telling its lawyers. They were overwhelmed by the crush of cases, in much the same way that many prosecutor offices are. And that's why, in a decision about a year ago, Justice Kennedy wrote, "We are a system of plea bargains, not a system of trials." Because everyone is forcing through the system far too many cases with inadequate lawyers on both sides, and the prosecution is engaged in a wide variety of coercive plea bargaining practices to which this defense succumbs, sometimes because they feel they have no choice, but in my view, something to which they should be challenging over and over and over again. Let me conclude these remarks by simply saying I have concerns about the future of public defense. The road ahead is going to be difficult to have truly genuine reform. There are problems of funding. There are problems of independence. There are far too harsh punishments imposed with mandatory sentencing and a sentencing scheme that allows persons to be put away for nonviolent offenses for life as a result of prior misconduct. Far greater financial resources are necessary, and I also believe there are major structural changes that are necessary in the way we go about delivering public defense services. But I'm absolutely committed to the proposition that it's important for lawyers to be concerned about what goes on in the criminal and juvenile courts. And one of the terrible mistakes I think that has been made is that we have relied too much on public defenders, and I am a former one. But that private bar needs to be desperately involved. They need to be screened, they need to be well paid, they need to be monitored, but they need to be in the game, the same as public defenders, because it's that private bar, much more so than public defenders, who can be a very important force for effecting change in public defense in America. And as soon-to-be law graduates, you too, if you are concerned about justice, should be concerned about this problem.
I realize that some of you are going to have to leave in a few minutes and go to class, but I would like to say just a few words, and then I'd like to turn it over to your questions for these wonderful speakers. And I think you can certainly understand the passion with which Norm was just speaking, given the things we heard from both of our speakers. You know, you've heard a number of compelling accounts of cases in which defendants received ineffective assistance of counsel, or perhaps in some cases no counsel at all. And a number of these cases that you've heard about involved relatively low-level crimes like stealing firewood, but you shouldn't assume that these problems are limited to such low-level crimes. There's a guy by the name of Paul Gregory House who ended up spending 23 years on death row for a crime he did not commit, because he had a trial lawyer who simply failed to investigate his case. He was charged with the murder of a young housewife in Luttrell, Tennessee. The murder occurred in 1985. House went on trial in 1986. The conviction was based entirely on circumstantial evidence, primarily two pieces of circumstantial evidence: some blood stains that were found on the jeans that House was wearing, and some semen that was found on clothes of the victim that was consistent with House's blood type. That was the only kind of testing they had back in 1986. Very primitive kind of physical testing. House steadfastly maintained his innocence throughout. His defense lawyer at trial did not discover something that was only discovered about 15 years later by the federal public defender. House, let me back up. House was convicted at trial, was sentenced to death. He filed pro se a post-conviction motion alleging that his trial lawyer didn't fight hard enough for him. He eventually got a lawyer appointed to help him with his state post-conviction, but when that post-conviction motion went up on appeal, his appointed lawyer dropped the argument that the trial lawyer had not been effective in representing House. Never even called the trial lawyer as a witness and then dropped the issue on appeal, which was held later by the state courts to be a waiver of any challenge to the effectiveness of House's trial counsel. House kept filing pro se motions. Eventually, he got a pro se federal habeas petition together, and in it, he alleged that both his trial lawyer and his state post-conviction lawyer were ineffective, and that he was innocent. And he got a federal public defender. And for the first time, he got a lawyer who actually did some investigating. And what that lawyer found out was that the blood that was on House's jeans got there because the prosecutor bundled up those jeans with vials of the victim's blood and had the police drive them to Washington, D.C., which was their closest, most accessible crime lab. They sent them to the FBI crime lab in Washington, D.C., and the box got disturbed in the trunk, and at least 2 vials opened up in the box. The inside of the box, when it arrived in the FBI lab, was full of the victim's blood. No wonder there was blood of the victim on House's jeans. The semen was tested later and was found not to be House's. Now, you can't really blame the trial lawyer for that because they just didn't have those tests in 1986. But finally, the federal public defender discovered that the victim's husband had confessed to the crime to 2 women in the community during House's trial. And the trial lawyer never bothered to even look into the husband's background. He was a wife beater, and he had confessed that he killed his wife. House's case went all the way to the Supreme Court. In 2006, the Supreme Court looked at all the evidence found by the federal public defender and concluded that no reasonable juror could have possibly found House guilty beyond a reasonable doubt, and therefore allowed him to go back to federal court and litigate whether his trial lawyer was ineffective. It then took House almost 3 more years to get off of death row, even after the Supreme Court ruled that no reasonable juror could have found him guilty. At one point in a newspaper article in the Knoxville newspaper, the prison warden who was in charge of death row was quoted as saying, "The Supreme Court held that no reasonable juror could have found House guilty. So why is he still here? Why is he still here?" He finally got released in 2009. I want to ask our guests to just comment on one question. Why are we still here? 50 years after Gideon. You know, a student asked me in the hall before the session today, well, you're moderating a panel discussion. I know what one side of the argument is. Who's arguing the other side? Who's making the anti-Gideon argument? Nobody's going to make an anti-Gideon argument. No reasonable person would disagree, at least openly disagree, with the proposition that anyone charged with a crime for which they could face prison, the death penalty, should be represented by at least a minimally competent lawyer. Even in Gideon itself, Florida, which was trying to resist the constitutional recognition of the right to counsel, Florida sent around a request asking other states to join them in an amicus brief. They only got 2 states to join them, Alabama and North Carolina. 23 states filed amicus briefs on Gideon's side of the case. Walter Mondale was the Attorney General of Minnesota, and when he got the letter from the Florida Attorney General, he was so outraged by it that he made a bunch of phone calls and got a bunch of other AGs around the country to file briefs on Gideon's side. No reasonable person stands up against the Gideon right, so why are we still here? What's wrong? What's preventing Gideon's promise from being fulfilled? I'd just like a couple words from our experts on that.
I think I answered it. I think it's a hard slog. I mean, you look at the vast array of social needs in this country that are unmet, and here you're seeking funding for people that much of the public thinks are guilty of crimes. And it's unpopular. I mean, it's the other side of the coin of why we have so over-criminalized America, with many more federal crimes, state crimes, harsher punishments, mandatory minimums. That's what's politically saleable. This isn't politically saleable. This is a hard slog.
So it's politics.
I think it's largely politics. I mean, decades ago, Norval Morris, former dean at the University of Chicago Law School, wrote a book about the politics of crime. And you could write it again and again ever since he wrote that book back in the 60s, as I recall, or early 70s. But I think that is much of the problem.
And David, you pointed out how the right to counsel has been recognized since colonial times and judicially recognized for over 100 years, going on 150 now. What's your view about why we can't get this right, given the broad societal acceptance that there ought to be such a right?
Well, I certainly agree with Norm's position on the political aspect of it. The other thing I would add, and we were talking about this actually on the car ride up here, is just the culture of the courts in America. When you get out of law school, you're not trained to be a prosecutor or a public defender. You learn aspects of law, and then you learn it when you go into those professions. And so you learn the culture that's already there. People ask me over and over and over again, well, do you sneak into courtrooms? You know, how do you do it so that they don't, gin everything up? When the system's as broken as it is in our country, you can't fake it. You go in and you say, people think they're doing it right, but it's this massive volume of cases that came into the system in the 80s and 90s with the tough on crime movement that has just institutionalized these bad practices to the point where the people in the system can't recognize it. The fact that in courtroom after courtroom, when someone comes in for their arraignment, most places will say, please talk to this prosecutor. They're not even brought before a court or brought to be screened for indigent defense. They're told to try to work out the deal first. So there's this cultural piece that's a part of it too, in addition to obviously the political stuff that Norm has raised.
And what he's referring to is patently unconstitutional. It is also, in my judgment, totally unethical, something that I've been working on recently. I think it is totally indefensible for a prosecutor to have a conversation with a defendant who has not validly waived the right to counsel. The standards of the American Bar Association very specifically prescribe the practice, and if you look at the leading treatise on prosecutorial misconduct, it states categorically that a prosecutor may not engage in such practices. It happens all over the country. And it's one of the remarkable things about the criminal justice system. There are all sorts of practices that fly under the radar screen. There are practices of low visibility. And unfortunately, the culture within public defense way too often tolerates it because that's the way it's always been. And let me say, by the way, the Sixth Amendment was never intended, if you go back to its history, to guarantee a right to a lawyer for a poor person. Never was. The history of the Sixth Amendment was to guarantee that somebody who had the means could come into a courtroom with a lawyer by their side in felony cases because there had been some practice of disallowing it in England. Lawyers were not very favored people in those years, and they wanted to make sure that if somebody didn't have that if somebody had money and wanted to bring a lawyer in, they would be able to do so. So you might say it's judicial activism run wild by establishing the right to counsel by the Warren Court. Though I think even this court would accept that it's okay, at least to some degree.
I would like to add one thing. We've heard that it's society and politics. We've heard that it's the culture of the criminal justice system. I'd like to add one more to those of you who are soon to be lawyers. I think it's also individual. Those of you who've had my course in Crim Pro know about Dershowitz's rules. Dershowitz's rules, Alan Dershowitz wrote a set of rules that he believed described the criminal justice system. And rule number 1 is that all criminal defendants are in fact guilty. Rule number 2 is that all prosecutors, judges, and defense lawyers believe rule number 1. And at the individual level, that's the kind of cynicism that predictably, understandably, but nevertheless wrongly leads defense attorneys to write memos like the one that you quoted, Norm, where it's triage, where we don't have to start off believing that our client might be innocent. I'm quite certain that the lawyer that represented Paul Gregory House in a death penalty case took the non-actions, failed to do the investigation because he became convinced pretty early on that his client was guilty, and therefore there wasn't any need to investigate. So as lawyers, if you're ever in that position, hold the line, stand your ground, don't give up. Otherwise, those people will never get adversarial representation. Questions? Yes? Oh, sorry, I will let you applaud since some of you have to leave. Go ahead. Let's give a round.
I actually differ with some of what's been said here. I think the problem has to do with the fact that only liberals care about this. And I'm going to challenge you to tell me why conservatives should care about the system of indigent defense in this country.
Fair question, Janine.
Actually, I take a little exception to that, just because many of the successes that we've talked about have been Republican and conservative driven and led. The most recent ones, Michigan, Louisiana, Montana. I just came, as you were told, from Idaho, a very Republican state that's working on this. I think what you find is people just don't think about it. They fall into that tough on crime mentality. But when you present it as a tyranny versus liberty issue, and understand that the Sixth Amendment as part of the Bill of Rights fits right into that the primacy of the individual, not the government. That's a very strong, deep-rooted theme for conservatives in our country. And I think it's just getting them to see that what they think is happening is very different from what is. So I do think it's actually something that the Michigan reform actually was led by a Tea Party conservative who told me, I believe in small government, but what government's supposed to do is uphold the Bill of Rights. So I think we're seeing a lot more on that front.
I certainly think conservatives should care deeply about it, and certainly there are some that do, but it also amounts to spending money. And there are many of them that cannot get over the notion that the vast majority of people are guilty. They are, and therefore they simply don't want, if they're fiscally conservative, regardless of party, they simply don't want to appropriate the requisite funds. You know, the way it all developed in this country, and that's the reason I emphasize it, is it came as an unfunded mandate. Britain, earlier than the Gideon decision, passed a law, an act of parliament, which also came with an appropriation. That isn't how we progressed in this country. It was handed down to the states. And I just think that carried with it a certain amount of baggage. And we're still fighting that, just as Justice Powell understood back in 1972.
Any other questions, students who've stayed this long? Go for it.
So I have a question about the different models of public defense where you have contracts, or if you have something like a county system or a state system. Is there some empirical evidence that the state and county systems help young lawyers get to higher levels of competency faster? I'm kind of wondering if that might be an effective way of making the kind of political argument that might take to reform state systems.
What I've always said is that the delivery model is less important than meeting the standards like the ABA 10 principles. So one of the best systems in our country that Norm alluded to is in Massachusetts, the Committee of Public Counsel Services, which is basically an assigned counsel system, or was through much of its history. You can have good contract systems. The state of Oregon is entirely 100% contract, but they build into those contract the standards. They have a very a sophisticated matrix, for example, on caseloads and how to do that. So I think what's important is really a system that meets those standards. And so one of those standards we just brushed on lightly was training, and particularly new attorney training. Instead of just throwing somebody in with a caseload, actually, bringing them along, doing mentorships and other things. The system norm-led PDS has one of the very best training systems for new young lawyers. And so you can get it out there. And so I would look more to what services provide that training, mentorship, guidance versus, the model that it takes on.
I'll allow one more question, and then we're going to have to get these gentlemen some lunch. Yes?
One thing I've noticed, I've been working as an intern at a public defender agency for about a year now, is, there's really this massive imbalance of power. And I've seen over and over this situation where the attorney I'm working with, the client I'm working with, maybe we have this suppression motion, maybe we have all sorts of motions, and there's always this underlying threat. If you push something too hard, is this plea going to get yanked out from under you? Is your trial willing to go to trial and face 10 years, 20 years life when they have a plea that they can go home today? And, that it's tough.
That is why we have a system of plea bargaining and not of trials. Coercive plea bargaining practices, which I think, as far as their arguably being constitutional, date back to the decision in Bordenkircher versus Hayes, which you may cover in criminal procedure in 1978, as I recall, in which the Supreme Court made clear that a defendant who didn't want to plead to the charge that was offered was yanked out from under him. The prosecutor, as I recall, went back to the grand jury and indicted him as an habitual offender, and he went away for life. And the Supreme Court said, well, that's all right. That's within the discretion of the prosecutor. But they've found more pernicious ways, in my view, of dealing with that issue by, and this may be what you're talking about, a so-called exploding plea offer, which is available until 5 o'clock on Thursday afternoon. I tell the story in my book of a lawyer who was testifying in this challenge to the caseloads in the Miami-Dade County office. She was a Yale law graduate, undergraduate of Cornell College, Cornell University. She went to court one day with 12 felony cases that were supposedly ones that she should be ready to try. She also had an outstanding plea offer for a client that she asked to be brought up to the cell block behind the courtroom because she wanted to communicate the plea offer, which would have allowed him to serve his 365 days and go free and be on probation for several years. One of her cases went to trial, and she forgot to communicate the plea offer to her client. The next day, she called the prosecutor and said, I failed to communicate the plea offer to my client, and the prosecutor said, well, yesterday's deadline was yesterday. You don't have that deal today. Today, it's not available. That client went on to plead guilty, was put in prison for 5 years, and was labeled a sex offender for life. Now tell me, what principled basis is there for a prosecutor to behave in that manner? And they do it, in my view, over and over and over again, because they too are dealing with large numbers of cases before a judiciary that wants to see the cases moves through the system, and this is the way of leverage. But see what it does to the defense. The defense is supposed to investigate the case, be able to counsel the client, and here you are between a rock and a hard place. Make that decision by 5 o'clock in the afternoon and render effective assistance of counsel to your client. It's impossible. Can that be due process of law in 2013 in America? I simply can't comprehend it. But it's what goes on over and over and over again. It's actually going to be the subject of my next law review article, which I've got to stop writing them because it doesn't make any difference.
And I do appreciate the question because I knew that was something that Norm wanted to talk about. I think it's just, as I said, it's wonderful that we could wrap up this set of talks with, there can't be two people more appropriate to talk about Gideon and its failures and its its problems than the two people who we had with us here today. So once again, I want to thank both David and Norm for just a wonderful presentation.